Hello and welcome to the continuation of the Appellate Practice and Procedure course at Solo Practice University. I'm just going to jump into today's lesson, class number 4, which is Handling an Appeal, Preparing Briefs, and this is going to be part 1 of this lesson, as I'll explain in a few minutes. You should all know by now that briefs are important, extremely important, in the appellate process. As the first slide indicates, the introductory slide, most appeals are won or lost on the briefs. And that's something that holds true aside from the actual merits of the case. Sometimes cases are won or lost really on the merits, but as far as opportunities for advocacy are concerned, briefs are kind of where the rubber meets the road. Oral argument is a very important part of appellate practice, but as a practical matter, it is not outcome determinative in the same way that briefs can be. So that's the reason for the emphasis here, is that briefs have a much larger impact on the outcome of a case than oral argument does. The purpose of the brief is to persuade the court why your client should win, and we'll get into that in a few minutes. What we're going to focus on today in the overall picture of appellate briefs is an appellant's brief, the party who is bringing the appeal. And so this is part 1 of this presentation. Part 2 of the presentation, which we'll do next time, will focus on the appellee's brief, the appellant's reply brief, and so forth. So we're going to cover today some things that will be relevant to not only the appellant's brief, but also briefs in general. And so I'm going to move to that under the heading of the basics in a few moments. But after we kind of hit the basics, what we're going to focus on today is strategy and some of the details involved in presenting appellant's briefs. So moving to that slide that's entitled The Basics. I have mentioned in this course before the importance of legal writing in appellate practice, and hopefully you've received adequate instruction on legal writing. You've been told that you're a good legal writer, or you know that you're a good legal writer, and because that's just a critical tool in appellate practice. There are not many appellate practitioners who dictate their briefs, do it sort of by stream of consciousness. Most of us are very careful and thorough in how we prepare briefs, and it goes from starting out with ideas or outlines, and then sort of a drafting and editing process. And I mean, you might as well also be a good editor, because that's something that we'll get into a little later in the course today. But let me focus just for the moment on legal writing. Being a good legal writer, again, is something that really, if you don't have that skill, you may be the best oral advocate there is, but as I said, briefs are significantly more important than oral argument. And so I would suggest to you that you either work on improving your legal writing through taking workshops. Brian Garner has an excellent workshop entitled The Winning Brief, and he is, of course, an authority on legal writing. There are many other resources to draw from to try and improve your legal writing if that's something that you perceive as a weakness. And so moving on from that point, there's a reason why briefs are called briefs. And it sounds like a cliche, but judges universally tell appellate lawyers briefs should be brief. My personal approach to that issue is, if I've got a 50-page limit, which is generally the limit in state court in Texas, I will almost never go beyond about half of that. So if I've got a 2 or 3 issue case, I've got a 50-page limit, I'm generally aiming for 25 pages for a couple of reasons, but not the least of which is the judges really don't appreciate briefs that are overly long when they don't have to be. One of the marks of a skilled appellate practitioner is to be able to take a case that's very complicated, whittle it down to the bare bones, and present those in a very coherent, abbreviated way so that the court can understand the issues, understand the facts, understand the law, and make a decision based on that presentation. In writing briefs, really one thing to consider is who your audience is. That's one of the most foremost considerations, is who are you writing for. And while it's tempting to write briefs that will be pleasing to the client, attack the other side and show how that judge was just ignorant of the law, that's really not an approach that will be received favorably in appellate courts. Write for the audience of appellate justices who are looking at two sides of a case, and whereas your side may see it as being a slam dunk, well, the trial judge just got it wrong. The old adage that there's two sides to every story holds true in appellate practice as well. So, one approach to this, and I'll skip to the end of the slide just to mention it, is to try and be helpful to the appellate court rather than quite so adversarial. In other words, there's a trend in modern appellate practice, and I think this has probably been true for many years. It's just something that people are actually talking about now, toward presenting yourself as an advocate as being helpful to the court and helpful in the court's decision-making process, rather than as you might be in a jury trial, quite so adversarial, pointing fingers at the other side or pointing fingers at anybody, a witness, and so forth. So consider who your audience is and try and write something that would be persuasive to that audience, and that'll take you a long way. And then finally on this slide, it's critical to use proper cite form. Some folks may think that that's something that just law review dorks worry about. That is not the case at all. The judges generally know what proper cite form is. Their law clerks or briefing attorneys generally do as well, because most of those folks have been on the law review in their respective law schools. And many of the folks who are interested in appellate practice participated in law review, and that may have been what got you interested in doing this kind of work. A brief that does not show knowledge of proper cite form is less credible than a brief that does. It sounds ticky-tacky and actually somewhat ignorant, but I'm here to tell you that when I read a brief that shows a lack of knowledge of proper cite form, I instantly think that this person is not as capable an advocate as they might otherwise be, even if they are very bright, very articulate, and so forth, but they don't seem to know the rules such as they are. There is room for disagreement on this issue, certainly room for disagreement about what is proper cite form and what is not, and whether you should be all that concerned about proper cite form following the Blue Book if you have a state equivalent of the Blue Book. My view of it is, why even open it up to debate as to whether you are a skilled appellate advocate if you will just follow the Blue Book, follow the local conventions for citations for local cases, if there are any, and then you sort of remove that issue altogether from the equation, and you can focus on your advocacy skills and representing your client. The next slide continues discussion of some of the basics for appellate brief writing. Don't assume that the justices know what the law is, although they very well might. One way to approach writing appellate briefs generally is to write it to an intelligent but uninformed audience, and because judges, even though they've probably decided many cases in their career, judges don't always know every aspect of the law either. So there may be some very fine point on summary judgment procedure that a judge sitting on your panel who happens to draw the opinion isn't aware of or hasn't heard of. Or if you're dealing with criminal cases, you could have a judge who has focused on civil practice through his or her career and needs a little education on what the law is. So I think a good rule of thumb to follow is, know that you're writing for an appellate justice, but also write the brief in such a way where an intelligent person who is not informed on that particular topic could understand it and then could move on from your explanation of the law to how the law applies. One thing that you see pretty often in appellate briefs is a need to refer to parties by some shorthand reference, such as when you've got A, B, C, D, E, F, G Corporation, or John Doe Appellant, Jane Doe Appellee. The easy thing to do is to create what I call alphabet soup and to say ABC Corporation, or usually it's not even something that flows off the tongue like that. It's EZT as being the shorthand version of whatever the company's name is. That is something that appellate judges routinely say that it is distracting to them, and as they read appellate briefs, I should say, just generally. And so it's something really to try and avoid if you can, unless you've got, like the IRS, it's an entity with a very recognizable abbreviated name using letters. I would try and stay away from that. Instead, let's use the IRS as an example of something else you might do to try and shorten that party's name in referencing the party throughout the brief. You could say Internal Revenue rather than the Internal Revenue Service throughout the entire brief. So recognizing that there is often a need to try and shorten references to parties' names, try to come up with something that is going to be understandable and easy to follow, but doesn't just throw a whole bunch of letters at the court so that it can get kind of confusing. And judges also routinely say, refer to the parties by their names, especially if they're individuals. So instead of saying appellant contends blank blank blank, say Doe after explaining who John Doe is, say Doe contends blah blah blah, and that way you've made it clear. You should make it clear early in the brief who the party is. But once you do that, these judges are generally intelligent people, and they'll be able to follow it if you just refer to the parties by their names rather than their procedural designations. And it makes reading the brief a lot easier and a lot more comfortable. It makes the process go more smoothly as well. Editing, that's probably something that everyone watching this has heard about before. A big part of brief writing is editing. Brian Garner refers to writing as sort of a couple of different phases. The first of which is the madman phase, where you just put everything on paper that possibly comes to mind. And the way to take whatever brilliant product might come out of that madman writing phase is to edit that and reorganize it and put it in coherent terms that make sense to the appellate judges. And so you should go through multiple editing phases, even if you don't follow Garner's approach per se, and you write in a more linear way. I can't say enough about the time that should be spent on editing briefs. It's one of the most important processes that you can go through. You'll catch errors in your word choice. You'll decide that you should say something a little differently to be consistent with a certain case that you're trying to emulate, or just overall, shorten the brief and improve it and make it more readable. So edit, edit, edit is the adage, or the mantra to lay down there. And one thing that maybe sometimes kind of a luxury, especially for solos, is to be able to put the brief down for a few days before it's actually due and you're going to file it, and work on something else for a while, get your mind off of it, and come back during the editorial process, and having laid off of it for a little while will give you some, have you be able to step back and have a little different perspective on the brief. And because if you're like me, if you look at something over and over and over again, pretty soon your eye starts just kind of glazing over it. And if you get away from it for a couple of days, I think it helps the editing process a lot, especially if you're the only editor of your work product, to be able to put it aside for a few days and come back to it. And the next slide, the final slide on the basics, on kind of a related point, another way of improving the editing process overall is to have someone else actually proofread and edit the brief. If you have that luxury, if you have an office mate, your significant other, and it can be even useful if the person's not a lawyer, because it goes back to that whole idea that I was getting at earlier about writing to an audience that's an intelligent and sophisticated person who's uninformed about that subject matter. If you can explain a complicated legal issue in terms that a layperson understands, then I think you're doing a great job. So if you've got a layperson available to you, especially one knowledgeable in English and maybe even editing, it's a tremendously useful thing to have. You might have a legal assistant who works for you. That person can be a good resource for proofreading, and I'll mention specifically site checking as well, because although that may seem like something of a luxury, it's something that we should all try to do, to have a third party pull our cases, make sure the case citation, the case names are right as the cases are cited, make sure the reporter citations are correct, and make sure even that the jump pages or the pinpoint citations are correct, because these are things that also play into credibility and how the justices on your appellate court in your case are going to see you as an advocate. If you're consistently citing cases incorrectly, if you're consistently providing pinpoint sites or jump sites that are wrong, or that don't, if you haven't included a parenthetical, don't take the court to a place in that opinion where it's apparent that what you're arguing is directly related to that case and that case is helpful to you. That is something that's going to negatively impact your credibility with the court and overall be something that has an adverse effect on your client in your case. So site checking, proofreading, very important. In my practice, I've always made a point to send briefs outside for copy. I'm sure that if I chose to sit down and stand by a copy machine and make all the copies that were necessary and use a binder and actually physically bind the briefs, I could do it, but there are litigation support copy places who this is what they do. They've learned over time to deal with lawyers and their usual last-minute deadlines, and so if you haven't found one, ask some of your friends for a copy shop that they can recommend which handles litigation matters. Those folks are really well equipped to put your brief together for you on a relatively short turnaround. It's especially useful if you get to know them a little bit and communicate with them about what your needs are, your preferences for types of cover, if you use tabs, that kind of thing. Sometimes they will be able to lay those things out ahead of time, which will expedite the overall process of completing your brief. So it's a time saver for you. It's an investment in money that hopefully the cost of that you can pass on to your client. It's just a cost of doing business. But I would certainly recommend that anyone doing appellate practice have their briefs copied and bound professionally. When you get up to the U.S. Supreme Court, of course, you don't have a choice. The Supreme Court has very specific rules on how briefs would be presented and printed and all that good stuff. But most state courts and federal courts, circuit courts even, are not quite as strict. But just know what the local conventions are, follow them, and have somebody else do it for you if you can. And then, of course, I'll stick to my mantra of know and follow what your jurisdiction's rules are. I've also mentioned local practices. Here is a situation in terms of putting together briefs where local practices can be very important. So know what the rules are, know what other practitioners in your area, in your locality you're doing, and maybe even if you can, go to a seminar. If you're somewhat unfamiliar and you're just breaking into this practice area, go to a seminar that talks about appellate practice, and specifically, try and learn what appellate practitioners in your area do as far as preparing briefs, what the norms and conventions are, and that will help you a great deal. So those are some sort of broad perspective points about briefing in general. I'd like to move now into the idea of preparing an appellant's brief. You're taking up an appeal, you've perfected appeal through a notice of appeal or equivalent, you got the record in, now you're sitting down to prepare the appellant's brief. What are some of the things that go into that that you need to be mindful of? And the first one, we've got a slide entitled Issue Selection. That's an extremely important exercise to go through preparing an appellant's brief. That observation will apply also to appellees, and we'll come to that in our next lecture. But issue selection, is a critical phase. I think it's commonly accepted among appellate practitioners and judges in this day and age that really you ought to limit the number of issues or points of error that you're raising to 2 or 3 if you can. Anything more than that, and the judges, their eyes start glazing over and they start saying, okay, we've got a brief now with 10 issues or 10 points of error raised. How many reversible errors can you really have in a trial? Probably not 10. So that's one reason why the courts like to see a smaller number of issues. And sometimes, honestly, you have to make difficult decisions in working with the trial lawyers and working with the end client on what issues are going to go away. I've had to do that many, many times and explain, look, Mr. Trial Lawyer, Ms. Client, while I know that you were really offended by the fact that this evidence got in or this evidence was excluded, the standard of review for the admission of evidence is going to be so high. You've got so many other important issues in the case. We need to really focus hard on the issues that have the greatest chance for success in changing the outcome on this case. And 95 times out of 100, I would say, evidentiary error is not going to get it done. So if you've got other points that are stronger, I would certainly guide the client away from the weak points and help focus on the points that are going to give you the greatest chance for success. Most often, that's a couple of 3 points at most. There are different ways of phrasing issues, and I've used a variety of these approaches. You see basic issue statements or questions, like the one I say that you should avoid here at the bottom of this slide. Did the trial court err by granting summary judgment for the defendant? Well, that states an issue, but it doesn't tell you anything about the case. It doesn't tell you what the law is that the court, that the appellate court is going to be getting into, if there's some nuance in summary judgment law. It doesn't tell you if there's an evidentiary issue, if the law is settled and the trial court just misapplied the law. It really doesn't give you any information about what the case is about. It's just extremely dry. So there are better ways of phrasing issues than that. Simple statements or questions can still work just fine if there's some additional information weaved into those. Or there's another concept. It's another Brian Garner concept called deep issues. And really, which one of those you use is largely a matter of preference and whatever the local requirements are for your appellate courts. Some courts write into the rules that the issue statement should be short and concise. And if that's the case, you don't necessarily want to go toward the deep issue, which what that is a couple of sentences, 1 or 2 sentences, explaining very briefly what the relevant law is or what the key facts are, followed by a question that then poses the issue for decision on that one point. And so if we move to the next couple of slides, you'll see what I'm getting at as far as simple statements versus deep issues. I've got some examples here. The first one of those is, these are what I would consider to be effective simple issue statements. They're not deep issues in that they're not written as more or less like syllogisms, which the next slide is an example of deep issues, and you'll see what I'm talking about if you when we move to that. But these kinds of issue statements are much more effective. For example, number one, did the district court correctly enter summary judgment against all former employees on the issue of protected political speech when the county's motion limited that ground to 4 specific plaintiffs and the rest received no advance notice that the district court would rule against them on that issue sua sponte? All right, that tells you a whole lot more than did the trial court err by granting summary judgment for the defendant. It gives you a sense of what the case is about, the basic issue that's in front of the court with respect to that procedural claim. It's a summary judgment. You know that the district court granted it. You know that they're, from looking at this issue that involves the question of protected political speech, that the county moved for summary judgment, but that there is a perceived procedural problem with that motion, in that not all plaintiffs were pointed out in that motion as being subject to summary judgment. And so these are just some examples, and yes, it's from a case that I've worked on. Those are the easy ones for me to grab. I have, as I say, I've done it both in terms of ordinary, simple issue statements where I try to get into some detail, and then again the next slide of deep issues. And there's a lot of debate on which way is the right way, and you'll find that over and over in appellate practice. What's right? Should you put footnotes in the briefs? Should you use footnotes for your citations, or should you cite in the text? For every observation like that, there is a sharp difference of opinion, and I think largely it comes down to your preference as an advocate. I think that's largely true for how you phrase issues, with one exception, and that is if your court, your appellate court, has a specific way that it wants it done, and that's reflected in either the rules of appellate procedure that you're following or in local rules, which I would be mindful of as well. But this slide has a couple of examples of deep issues where it follows the syllogism type approach. There's some background information provided, and then it works up to the ultimate question. And here, did the district court abuse its discretion by awarding the diversest parties $79,631 in attorney's fees as sanctions against 360 training? That probably could be a standalone issue, but without the context that you put in front of it, it's not quite as effective. And the other thing that I think people believe about deep issues is you really get into an opportunity to try and start persuading the judges early by presenting issues this way. If you tell the judges more or less, here's what the law is, and here's a brief statement of the facts in our case, and here is the question, you're suggesting to the judge what the answer should be. And there's a lot of value in doing that early in the appellate process, because you want the court to find your brief to be persuasive. So the next slide, tables and indexes. Aside from how you phrase the issues, this is actually one of your first, if not the first, opportunity for you to show some advocacy to the court. Correctness in the formatting and cite form and so forth, like we've discussed a little bit earlier, is very important. The court is going to turn to the table of contents in your brief as one of the very first things it looks at. And within that table of contents, it's quite effective if you restate your issues and if you reproduce your argument outline. Because what that does is it gives the judges a preview into your case and gets them sort of kick-started thinking about the issues that you're going to be talking about and the law that's related to that. And so I view the tables and indexes as something that's critically important, being one of the first things that the judges look at. As far as timing of preparing these, I've included this first, but it, along with the summary of the argument, the table of contents and index of authorities, or table of authorities it can be called depending on jurisdiction, is one of the last things you ought to prepare, because the body of your brief is going to be changing throughout the editorial process. You might change your headings, you might change the order of your argument, you might change what cases you cite, and so it ought to be, the tables and indexes ought to be one of the last things you do before submitting the brief for filing. I have here on the next slide a sample table of contents. It's from one of the briefs that I used earlier in providing an example of the issue statements, and deep issues more particularly. So, I mean, this is just the first half of a page, basically, because of the limitations on the size of these images in the slides. But you get the idea about, you know, what it is. The whole goal here is to try and sort of signpost for the court what's in the brief and how the argument is presented. And you might want to do this anyway, but many sets of appellate rules have set requirements for the things that are going to go in the table of contents and the index of authorities. And so, you know, be sure you follow those as well. But you can see from this example that you're sort of following a progression on how the argument is structured. If you could see the whole page, you'd see it even better. The next slide is a sample table of authorities. You know, there are different ways of presenting these. I usually present case law or cases, statutes and rules, and then other authorities under headings like that, like you see the cases heading in bold here. The way that I present the cases, and I've seen many other people do this the same way, is to have the case name on one line and followed by the rest of the site indented on another line. Depending on how long the case is, you might have to split that onto a third line. And then, of course, you've got references to the pages in the brief where those cases are cited. You know, but a court can look at this quickly and immediately ascertain whether you're someone who knows how to cite a case, because you've got all of your case citations and all your statutory and other authoritative references in your table of authorities. And you know, if the court wants to know, well, the Celotex case, that's a seminal case in summary judgment in federal practice. I want to see what they say about that, and they know, you know, the court knows what page to go to get to that. Let's talk about the statement of facts. The statement of facts is your opportunity to tell the court a story and to really get the court's attention and help the court understand, you know, what are the significant facts of this case. It's sort of an art form in itself, preparing a statement of facts, because you've got, you know, quite often a very large record. If you've got 2 or 3 days worth of jury trial, you can have you know, a very voluminous record with a lot of testimony. And so what you have to do is figure out, you know, what are the important facts in the case. And so I've got written here, think thorough but short, just enough to cover what's necessary to understand and decide the case. That's what I would recommend, because you don't want half of your brief to be made up of a statement of facts, a good amount of which is really not relevant to the issues that are involved in your case. Appellate judges, I think, universally, or almost universally, say, tell us what we need to know about the facts. Don't tell us a whole lot more than we need to know, because, you know, as the judges read through the fact statement, they don't really know yet what's relevant. And so by providing a lot of extraneous facts that aren't necessary, it has a tendency to confuse the judges, or at least raise some issues about what's important and what's not, and the judge, you know, may spend more time on unimportant facts than they ought to. And so it's really quite critical, I think, to be thorough, but don't include a whole lot more facts than what are absolutely necessary to decide the case. Another critical issue is you need to just be upfront with your bad facts. You can sort of draw the sting away from bad facts by including them in your own statement of facts as an appellant, and I think that's a big credibility enhancer with an appellate court. If you are willing to confront the bad facts in your case and deal with them, then the other side can't beat you over the head quite as effectively with those bad facts. You've had an opportunity and taken advantage of it to sort of shape the appellate court's view of what those bad facts are and how they ultimately impact the case. And you also have the opportunity to sort of minimize their overall impact on the broader story that you're telling in this statement of facts. And so disclose the bad facts. You don't want to write around them too much. You want to confront them. And you don't want to dwell on them too long, but you want to at least make reference to them, acknowledge that they exist. And that will help you overall in your effectiveness as an advocate. And that really, I think, applies to both appellants and appellees equally. The other thing about a statement of facts is, this is not really the place to be arguing. Our rules in Texas actually state the facts, plainly and concisely without argument. And I always get a little bit irritated when an opposing counsel decides to start arguing their case and throwing in case citations in the fact statement, because there's really, this is not the place for that. The place for that is your argument section. So with that said, though, there's absolutely nothing wrong with shaping the story in a way that's favorable to your client's position, as long as the record will support what you're doing. You can take that opportunity also to apply some persuasion techniques to the appellate court, hopefully to help the court see the case your way. Moving to the next slide, standards of review. We've talked about these a little bit in previous presentations. This is really where they get to be important, is in brief writing. It's certainly important in evaluating appellate matters, but here is where you've got to show how the standard of review, what the standard of review is, and how it applies, particularly from the appellant's perspective. Too often I see appellate briefs written that don't even reference the standard of review, that just say, well, here's the law and here's what happened and the court erred, and so therefore appellate justices, you should reverse. That's really not an effective approach. Appellate judges live and breathe standards of review, and by that I'm talking about things like abuse of discretion, plain error in a lot of federal cases, de novo in many summary judgment cases, and in other cases. Sufficiency of the evidence would be another one. You've got to acknowledge what the standard is based on your particular issue that you're presenting to the court, and you might have to, in doing that, if you've got 2 or 3 issues, you may have to lay out 2 or 3 different standards of review. You can do it effectively in a separate section that just lays out the standard of review overall, particularly if it's one standard that you're applying, or you can, depending on what your local rules say, you can incorporate the standard of review into, if you've got 3 issues and you're handling it under 3 Roman numeral headings, you can just insert a standard of review discussion at the beginning of every one of those, and I think that's an effective way also of bringing the issue of standards of review to the court's attention and laying out what those standards are. So as I referenced in the slide here, a credible appellant's brief is going to not only address them, but it's going to embrace the standard of review, because you've got to demonstrate to the court why it is that your case jumps that hurdle. And frankly, that's what standards of review are. When you get into something like abuse of discretion or plain error, the Court of Appeals is giving a lot of deference to that appellate judge or trial judge, and so you have got to jump an exceedingly high hurdle to demonstrate why whatever it is that the trial judge did was erroneous and why you should get either a different outcome directly in the Court of Appeals if the record and the law supports it, or why you should get the case sent back down to try again and try to get a better outcome for your client. And then the last point on standards of review that I wanted to make for today is it's really not enough to tell the court, what the standard is and reversal is warranted, because the standard is met. You've got to demonstrate why the standard has been met. So in abuse of discretion cases, for example, one of the hardest standards to meet, cite the court to other cases where in a similar procedural posture, appellate courts have held there to be an abuse of discretion. That's an effective way of making that point. Think hard about how it is that you can persuade this appellate court that this is a case where the standard of review has been exceeded and that it therefore ought to grant you the relief that you're looking for. All too often, I think, lawyers generally, but appellate lawyers are no exception, say, well, A plus B, so therefore C. Well, that's true. That may be true. But A plus B, providing some additional explanation and ultimately leading to C, the conclusion, is much more effective than just trying to allow or trying to have the appellate justices figure it out for themselves. Let's just show them why the standard review has been met. On the next slide, talk a little bit about summary of the argument. Pretty often this is a required section in appellate briefs, and even if it isn't, you probably ought to include one because it's one of the things that the judges look at first, along with the tables and indexes. Just like the tables and indexes, the summary of the argument is something that ought to be prepared toward the end of the briefing process, maybe even after you've gone through some editing, maybe after even you've put the brief aside for a few days. And the reason for that is, it's, I think, helpful to see everything that you're going to present in the brief and bring it all together in a very coherent few paragraphs. It doesn't even have to be long. Distill it down to the bare bones of the argument, but including enough information so that you can, the appellate court, by reading this section, knows what the case is about and gets an idea of maybe even of how it might come out. So again, it's the argument, not only the argument section that we're coming to, but the summary of the argument is a very important opportunity to persuade the judges by telling them what your case is about and nudging them toward what you want the outcome to be. All right, the meat of an appellate brief, as we go into in the next couple of slides, is the section on argument authorities. And there's really, I don't think, much debate anymore about how to approach this generally in terms of the order of your arguments. If you've got a couple of really strong arguments and one that's one you should include but is not as strong, you're going to want to include your stronger arguments first. And I think generally you always want to lead with your strongest argument, the one that's best for you on the facts and the law if you can. Now, there are some exceptions to that rule, such as when one of your arguments leads to rendition of a judgment in your client's favor if you win. Another one leads to remand for a new trial, which wouldn't be as good a result as a rendition of judgment for your client from the appellant's perspective. So sometimes you have to make some judgment calls about which one of those go first. Obviously, you want to try and get rendition when you can. So you might, if the arguments are pretty close together in strength, you're probably still going to want to put the rendition point first, even if it's a little bit weaker, because that's the one that could get you the best possible outcome. And frankly, if the court goes your way on that, it may not even reach any of the other issues. So that's something to take a look at closely. Briefs need to be thoroughly researched. The law, you need to have a very firm understanding of what the law is that applies, not only in terms of the standard of review, but the substantive law. And my view of how to present authorities in a brief is you should rely on the strongest authorities that you can find. For example, in a state law case, cases from the Supreme Court or the highest court in your jurisdiction. Generally, that's, rely on those whenever you can, and then after that, what I like to do, even though they're not necessarily of greater weight, is try and cite cases that were decided by the court that's deciding the case in front of it, the case you're bringing up on appeal. For example, in the Court of Appeals here in Austin, it may have read the law of summary judgment, or let's use jury charges as an example to just go to a different area. The Austin Court of Appeals, may have read the most recent Supreme Court case addressing jury charges the same way as the Dallas Court of Appeals. But if you've got a decision out of the Austin court that applies that rule, then cite it as opposed to citing the Dallas case. The Dallas case is probably just as good on the law, but the Austin court, if it's a panel of judges from that court that are deciding your case, are probably going to be a little more persuaded by a case out of their own court than one from a couple hundred miles up the road. So, you don't have to put in long string cites if you've got a settled legal issue, or if you've got a definitive authority. There's probably not a need to follow the law review convention and cite case after case with secondary sources, but provide the court with the strongest authorities that you can find on that subject. And then, much like with confronting bad facts, you need to confront the weaknesses in your case, and authority that goes the opposite way. And it's the same principle as what we talked about in the statement of facts. You need to show why your client's position overcomes those bad authorities or bad facts, and you gain credibility with the appellate court in the process. What you don't want to have happen is you slip over and hope that the other side doesn't notice this case that really speaks to the issue that you're working on, so you don't raise it in your brief as an appellant, and then sure enough the appellee in their brief says, well, the appellant ignores so-and-so case, which is on point and authoritative and in fact dispositive, worst case scenario for you as an appellant, and that really makes things look bad for you as an appellant if there is a definitive case out there and you don't acknowledge it, confront it, address it, deal with it up front, and explain why it is your case is different. I think that's a mark of good advocacy, to be able to even embrace authorities and facts that are unfavorable for your side and deal with them. And this also plays into the whole idea I discussed at the beginning today of an approach of helpfulness to the court. I think by acknowledging negative authority or bad facts, you're helping the court to choose between the two sides of the story. One thing that's unique about appellate judges is that they don't get to just read what's written for them for pleasure. They have to decide from sometimes two clashing views of what the facts in the law are, essentially who's right. And so the more you can present yourself as someone who's an advocate for one of the sides, yes, but also someone who appreciates what the appellate court's perspective is and is trying to help the court and make a decision, I think that benefits you and gives you a lot of credibility as an advocate. Okay, the next slide, we're still talking about argument authorities. The legal writing teachers will tell you this, and I think it holds true now. You want to break text up. Don't go more than a couple of pages without some kind of bold heading in your text. Studies show, I think, that it helps to re-engage the reader's attention to what you're reading if you do that. It also, I think, really helps if you have difficulty making transitions from point to point. A good substantive heading can help telegraph where you're going next, and I think it's something that is very useful in an appellate brief. I personally use Roman numeral outlines, Roman numeral 1 with subs A, B, and then subheadings after that, if appropriate, and I think that's an effective tool in organizing briefs. This is something, honestly, that you ought to sit down and do pretty early in the drafting process, is figure out what's your brief going to say, what's your outline going to be, what are your, if you have 3 issues, how are you going to phrase those 3 issues in terms of headlines, headings in your brief, and then what subpoints do you need to make under those to help come up with a very logical flow that goes throughout the brief that the judges can follow. And so, outlining a brief as part of the writing process is very important. Something else you want to do that I think makes for effective advocacy is, weave the facts into your argument. Don't just rely on your statement of facts to lay the facts out and then say, statement of facts, argument, law, result. Weave into your argument the critical facts, and you'll know what they are by the time you've drafted the statement of facts with the law in mind already, I would assume. Weave them into your legal argument, and I think that can make an argument extremely persuasive. As far as footnotes are concerned, I won't say never use them. They certainly have their place. Again, I don't want to get into the debate of whether you should use citational footnotes versus citations in the text. My personal preference is to cite in the text, because one side of that debate is you have the judges who are you got to read the text, go down to the footnote to see what the authority is, you go back up, next footnote they got to go down, and it's pretty disruptive. I tend to agree with that, so I usually put my citations in the text. But footnotes, if you've got a point that isn't really directly related to what you're arguing, but is something that you want the judge to be aware of, it's okay to drop a footnote and put that in there. Just if it's a substantive argument that you're making, most of the time, if it's worth doing that at all, it's worth including it in the text. Maybe you need to break it up into a separate paragraph. Maybe you need to break it up into even a separate section in the brief. And maybe you wind up not including it because you don't conclude ultimately that it's important enough to include in the text. So I'll just state a preference that generally you should avoid substantive footnotes if you can. All right, the next slide, moving on to, and we're starting to wrap up now, the relief that you're requesting in the brief. Okay, you need to consider very carefully what it is you want the court to do. And when you conclude what that is, ask the court very specifically to give it to you. Don't just say, the appellant respectfully prays that the court reverse the trial court's judgment, period. That's not enough. You're going to know from having researched and looked at the law relevant to your case whether you have a chance of getting a judgment rendered for your client, in your client's favor on the appeal. Usually that's going to involve some kind of pure legal issue or evidentiary issue where your client has conclusively established its position. It doesn't happen all that often. Or it could be that you're representing a defendant and the other side has put on its evidence, and the conclusion to be reached on appeal is that the evidence was legally insufficient, so therefore there's no point in going back and trying the case again, so you win, you get judgment for your client. But there's nothing wrong if you've got, especially if you've got different arguments that would lead to different forms of relief, to requesting that relief in the alternative. So as the appellant, you should ask for reversal and rendition of a judgment favoring your client if you can get it, possibly reversal and modification of the district court or trial court's judgment, which would be more favorable to your client than a new trial, possibly, or reversal and remand for further proceedings such as a new trial. one thing that all appellate practitioners should be keenly aware of is what the different possible outcomes of an appeal are, what the different possible combinations of types of relief could be in an appellate judgment. That's probably going to be included in your rules of appellate procedure for your jurisdiction. But I think if you haven't already become aware of what kinds of judgments your courts of appeals where you practice can render, I would take 20 minutes and familiarize myself with that issue, because that is going to come up repeatedly for you as an appellate practitioner. I mean, every brief you write, you're going to be asking the court to do something, even if you're the appellee. And so you need to know what it is that your courts have the authority to do in rendering their judgments. On the next slide, entitled Sample Briefs, I do have a JD Supra profile, and I won't go into explaining the details of what that is. Many of you may already know. But it's linked here in this slide, and there I have probably right now 4 or 5 full-blown appellate briefs that I've done that are just posted to that profile, to the JD Supra site. That's not nearly enough. I'm going to be adding a whole lot more work product to that site in the next month or two. But what I wanted to do here was just let everyone know, if you wanted to see how all this fits together from cover to back, as far as appellate briefs go, feel free to take a look at that site where I've got those posted. And you know, I'm not perfect. I know there are some errors in some of those briefs, but those were what I was able to put together and file. And if you have comments on them, I'm certainly happy to hear them. I'll take a look there. As always, you know, if you've got questions, give me a call during office hours. Please send questions for the official study group. I've got one that has to do with marketing and appellate practice that's been posted, and some ideas there, and we will definitely get into that at the right time. But otherwise, you know, I welcome your comments and questions there on either the official study group site or the appellate discussion lounge. So next time, moving to the last slide, what we're going to do is class number 5, which is the second part of preparing briefs. As I've said, we will focus in that class on the appellee's brief and appellant's reply brief, and a lot of the principles that we've talked about today will apply to those, but there's a little bit different perspective when you're responding directly to what other folks have written. And so we're going to focus on some different strategic issues that come into play in doing those kinds of briefs, and then we'll move on from there to the latter topics in the class. So until next time, I thank you for your attention, and we'll see you soon. Thanks.